So what is the difference between a will and a trust? So let's talk about that today. And this is a very abbreviated conversation. Happy to go offline and talk to any of you about it. I provided a handout that has a little bit more detailed information, and most importantly on the back side is a chart breakdown between the differences and the cost of probate. It's very handy. So, without further ado, when I meet with clients, I talk about the 3 levels of planning. Why? Because it's very important to know where you are at when we're talking about whether you need a will or a trust. And the 3 levels of planning are having no plan, which really is following the state's plan for you, setting up a will, or setting up a trust, whether that's a revocable living trust or a irrevocable living trust. And the advantages are scaled in the hierarchy in that having no plan, in the absence of a plan, is the least protection and the least amount of guidance to those that you're leaving behind, and is the most expensive. On the flip side of that, a trust provides the most protection for your inheritance that you're leaving behind in the most efficient way, both from a cost and a time perspective. So, what is probate and why do we want to avoid it? And I bring this topic up now because the main difference between a will and a trust that is often confused is that a will does not avoid probate. A will still is probated. So if you have a will, great, you're on level 2. You provided some more guidance to your loved ones. But you have not avoided a lot of the problems and pitfalls of probate, and here they are. Most people enter into estate planning because they want their affairs to be in order, to pass efficiently with a seamless process, and to avoid court conflict, and of course to be efficient as far as tax purposes and unnecessary costs. Probate frustrates all of these things. It is certainly something that causes great delay. Nobody likes to go to court. Why? Because you hurry up and wait. And that's the same with your estate and probate. You're going to wait 18 to 24 months in Orange County for average probate to pass through. Of course, that could be extended longer if there are any conflicts. It's public. That invites people to contest the estate. It invites negative bad actors, predators that have come in to try to lay a stake into your estate that might not actually have one. Plus, people are private by nature. You might not want the world to know what you own or how you may have wanted things to pass. There's also a lack of control through probate. People that are unintended beneficiaries might get a piece of your inheritance, distant relatives, because you haven't properly planned. Also, individuals could be appointed to manage your finances in incapacity, or certainly pass things down, people that don't know you, the court, other professional fiduciaries, people that in your family that might not be people that you would want to do that. And lastly, it's very expensive. And the expense is court costs, probate fees, and certainly taxes. The most tax inefficient way to transfer property through estate planning is through probate. And the taxes are estate taxes and they're income taxes, whether you're calling them capital gains taxes or otherwise. And also there are property reassessment taxes as well for certain parts of real property. Probate broken down by cost, and we'll just look at probate fees. Probate fees are separate from tax liabilities. So these are just fees, and I put together kind of a basic asset inventory for a middle-class family here in Southern California who has an asset of total assets of $1.2-ish million. Not hard to reach that, as you can see, and I kind of put in these people are very well-rounded and they have all sorts of assets, and here they add up to $1.2 million. Now, probate fees, there's a whole schedule for them, but on average, 3 to 8%, depending on where you are on that schedule. We'll just take 5 as a middle-of-the-road average. Here, if we apply 5%, probate fees are going to be $61,000, and that comes off the top. That's before any creditors get paid or anything is distributed to your beneficiary. So it's extremely expensive, especially when compared to the cost of doing an estate plan or setting up a trust. So what a will is, it's a document that expresses your wishes. Still has to go through probate and only comes into effect when you die. So if you are still alive but you're unable to make decisions for yourself and you've done all this great planning in a will, too bad, sorry, that's not going to go into effect. And this becomes really important when speaking about guardianship, because a will have a section in it typically that deals with guardianship for minors. But that won't come into effect because your will isn't coming into play if you haven't died. And let's say you're in an accident or become terminally ill and you're in the hospital and you're unable to make these decisions for yourself. If your guardians are named only in the will, then that hasn't come to pass, and there could be an issue where people are going to court to try to assert guardianship for your children. Trusts, however, are also legal documents that provide your instructions, but do so outside the confines of probate court. Do so immediately, so it avoids delays. You have more control over how your assets are going to go, and provides more flexibility for successor trustees, whether it's a spouse or beneficiary, of how things are going to play out. And you're passing your assets, most importantly, with more tax advantages and more asset protection. So how does it work? I describe to clients a revocable living trust, and we'll skip to this box here. It's like a box you carry around in a wagon, and you're walking around through life with a wagon, and in that wagon's the box. All the things that you own get put in the box, so if you trip and fall, you die or become incapacitated, everything doesn't spill out and become quite a cluster. Instead, somebody, your successor trustee, just picks up the handle of the wagon and keeps walking. And in this way, it ensures a seamless transfer of your assets and your property through life without anything spilling out. So what do we put in this open box? During life, you have a revocable living trust. It's an open box. You put all your assets with my fancy little pictures on there. Money, home, if you have business interests, the bike is personal property, and sometimes you name a trust to be a beneficiary of a retirement account or life insurance. All that goes in the box. In the future, we know for certain there's going to be a life event, your death. We don't like to think about it, but it is going to happen. We just don't know when. So this is an example of a joint trust. We'll just call it a husband and wife. And this is how a flow chart of what their trust might look like and how it might be structured. The first dotted line, the first spouse to die, what happens is that the box with all the assets becomes closed, and depending on what the rules that you establish and the designs are, the assets are protected inside that box. They're not sequestered, but they're protected. So they pass with protection with the benefit of being used by the beneficiaries in all the sorts of ways you get to decide in advance with your loved one on the top. And HEMS is called Health, Education, Maintenance, and Support. It's an acronym that is for Ascertainable Standards, fancy legal term. But that provides the trustee with the ability to use the funds in the trust to provide for your beneficiaries. And these are just some of the rules that you can establish. So while these assets are protected from who? Other people. Who are these people? Creditors, people filing lawsuits. They could be a ex-spouse through a divorce. These are all people and ways in which an inheritance could be attacked. And you could be passing something along that might be wasted away by other people. My mom always said to me, look, you're 16, I trust you to drive, I just don't trust everyone else to drive, so you're staying home. And the same thing is with a trust, right? It's like I don't trust you with my inheritance, I just don't trust the world, so I'm going to pass it to you in this protected box. So you can enjoy it while it's still being protected. The second line here identifies what happens when the second spouse dies, and we've indicated 1, 2, and 3 beneficiaries, 3 children maybe, it could be anybody, it could be charities, 3 charities. And you can set it up in a variety of different ways. Lifetime trusts, you can have AB trusts, you can do all sorts of fancy creative things. The point is we go through that, through a detailed consultation, an estate planning session with me, and we talk about what your needs are. But that's how a trust basically works. The big important thing when you set up your trust is funding your trust. That is renaming the assets from your personal name or through joint tenancy into the name of the trust. And this is something we help clients with because it gets overlooked. You can set up a fancy trust, just words on a piece of paper if you don't follow up with funding your trust. So those probate costs that we looked at before, through a trust, you don't have probate fees. You have more assets going to beneficiaries, more value, and taxes, question mark, can be mitigated through a trust. You're mitigating capital gains taxes and certainly estate taxes in a variety of different ways that we can get into in future conversations. And you get to control your inheritance so you can prevent that guy from getting everything at 18. So there's lots to talk about, and I'm available always to answer your questions. The difference between a will and a trust is you save money. So glad to help you and your clients do that. Just give Kevin Snyder and Snyder Law a call, and we'd be glad to have the conversation. So thank you very much.